Hello everyone, this is Peter Poon from eLaw Alliance. I have with me Herman Jangry. Today we're going to be talking about drinking and driving law. It's a very technical area of law and criminal law. Herman is going to go over some of the recent changes that's come into effect. So Herman, what are the laws for drinking and driving?
So yes, Peter, initially the laws for criminal impaired driving were under section 253 of the criminal code. That has been recently changed. The new section begins at section 320.11. The actual charging offenses are 320.14 sub 1 of the criminal code. Now this includes several things. This includes operating a conveyance while the person's ability to operate is impaired to any degree by alcohol or drug or a combination of alcohol or drug. Or it's within 2 hours after ceasing to operate a conveyance, a blood alcohol concentration that is equal to or exceeds 80 milligrams of alcohol in 100 milliliters of blood. This is commonly referred to as over 0.08. It could also be within 2 hours after ceasing to operate a conveyance, a blood drug concentration level that is equal to or exceeds the prescribed amount of whatever that drug may be. You will likely get charged for both impaired driving and 0.08, so those are two different offenses.
And Herman, we get asked a lot, but the code is very specific and they use very different words that we use daily. Can you tell us what conveyance means in the criminal code?
So conveyance basically covers things such as a vehicle, a vessel, an aircraft. All of those things come under a conveyance. Initially, the criminal code had those separated, but a conveyance entails all of those separate things.
And Herman, you mentioned 08. What does that mean? What is a limit for alcohol, or what does that exactly mean?
So, good question, Peter. So, as I mentioned, 0.08 is what the legal limit is for driving. If you are over that limit, you will be charged and you can be convicted of a criminal offense. So 0.08 means after you conduct a breathalyzer or through blood warrants that your limit is over 80 milligrams of alcohol in 100 milliliters of blood.
Herman, what's the charge for failure or refusal to comply?
Okay, so again, as mentioned, the criminal code has changed. This is now found under 320.15 of the criminal code. Essentially, it is when a demand has been made and a person either fails or refuses to comply without a reasonable excuse with that demand. This can be a demand for either an approved screening device or for a breathalyzer. So for this offense to be made out, it must be a valid demand. The person either deliberately refused to provide a sample or deliberately failed to do so. So in this situation, it must be considered whether that person actually understood the demand, whether they were able to comply with the demand, or whether there was something preventing them from blowing into that device. So there are people that have lung conditions where this may not be possible for them, and in that situation, there are different circumstances.
Herman, can you walk me a little bit through what happens if, let's say, I get pulled over by the police and they're making this demand? Usually, what is the procedure?
So initially, the first device that will be used is an approved screening device. The law used to be that an officer required reasonable suspicion to get you to blow into this device at the roadside. This is a quick instrument that happens at the roadside. It's very fast. There are a lot of laws involved in that. However, the law has changed. If an officer has that device with them, they can get you to blow in that device without reasonable suspicion. So keep that in mind. That has changed. However, that is something that a lot of defense lawyers like myself are against, and likely something that will be litigated in the future.
And you speak of this approved screening device. What is it?
So the approved screening device is a simple device that is used at the roadside. You blow into it, you'll blow either a pass, a warn, or a fail. If you do blow a fail, it is likely that the officer will then get you to accompany them to either a precinct or to a place where there is a breathalyzer where they'll get you to blow into that.
Now, the police always speaks of what they use the term indicia of impairment. What do they mean by this?
So police, when they stop you, they look at you and they find indicia of impairment. So this could be things like your eyes are bloodshot, they're glossy, they're very red. You could have slow movement, you could be fumbling with your documents. There's alcohol in the vehicle, or there's alcohol smell on your breath. You have slurred speech, you have a flushed face, you have dry mouth, you have difficulty in communicating. So all of those things are what an officer will look at when they first meet you, and after considering those indicia, they might have reasonable grounds to believe that you're impaired, or a reasonable suspicion to believe that you are impaired.
And Herman, can you explain to us a little bit about what's the charge for impaired driving?
So impaired driving is separate and different than the .08. The .08 is when you blow into a breathalyzer after the approved screening device back at a precinct, and you get over .08. Impaired driving can be established from any degree of impairment from slight to great. The ability to drive must be impaired by alcohol or drugs, or a combination of the two. So in this situation, it is not when you're blowing into a device. You can still be charged for impaired driving without ever having blown into a breathalyzer.
And earlier you spoke of both a breathalyzer and blood tests. Can you go over a little bit about what that means in terms of blood samples and blood tests?
Sure. So just to mention something in regards to what you said about the breathalyzer. For a breathalyzer, an officer needs to have reasonable grounds to believe that you are impaired. So they need both a subjective component and an objective component. So they must believe themselves that you're impaired, and that belief must be rationally sustainable on an objective basis. So now for blood, that is the same thing. There's several different ways the officer can try to get your blood. That could be, they can make a blood demand. That is in a situation where, due to your condition, you cannot consent to a breath demand. You could yourself consent to giving up your own blood. Of course, we would never recommend that. The officer may have reasonable grounds to believe that your ability to operate the vehicle was impaired by drugs and alcohol. They may, in that situation, request for your blood. There may also be a situation where they get a warrant. So they still have to have that same belief that I mentioned before. They have to swear an oath, and that's to go to a justice who can then issue a warrant. They could also get a search warrant for your blood. So this is after perhaps in a situation where a hospital has your blood, they take it for medical purposes, but an officer or the police then conducts a search warrant and gets that blood even after the fact. So there are a lot of ways that the police is able to get your blood.
There's also a term that's used in the criminal code. It's what we call care and control. Can you kind of go over that, and what does that entail?
So care and control is separate. It is now included within the criminal code as operate. It initially was separated, but it still was included within the same offense. So with care and control, you could still be charged and found guilty of operating a vehicle even if you are not driving the vehicle. So these are situations where you might be in the driver's seat, the vehicle is on, but you're not actually driving. So in these situations, there has to be a risk that you might put the vehicle into motion, and that risk can essentially be made out by any intentional course of conduct that you do. So even though a person might not intend that, the court can find that there was the possibility that the risk of the vehicle being placed into motion, and because of that, even though you are not driving, you could still be found guilty of this offense.
So does that mean that even if I'm just sitting in the driver's seat and I'm not driving the car and park on the side of the street, they still think that possibly I would be operating the vehicle or care control of the vehicle?
That's correct. You could still be found to be in care and control of the vehicle even though you're not driving the vehicle. So a lot of situations people say I'm not doing anything. However, if you're in the driver's seat and the vehicle might be on, you could be found in care and control, which has the same penalties and consequences of you driving the vehicle.
I see. And as defense lawyers, we always talk about the charter. Are there any charter issues with this new change in legislation that you can see, or that we've been following through the courts?
Yeah, so in any impaired or over .08, charter issues are going to be one of the most contested and litigated issues. For this new law, of course, with the new approved screening device that allows you to search without any reasonable suspicion, that's obviously going to be an issue that's going to be litigated in the future. Just Generally, for any impaired investigation, there's always charter issues in regards to a search and seizure, any arbitrary detention, any right to counsel, and any right to be informed of why you are arrested or detained. So all of those issues are very important. They all come up, they're very technical, and usually that's going to be one of the most litigated issues in terms of all those charter breaches for any stop for an alcohol investigation.
This all sounds very complicated, and it seems like it would be a good idea to speak to a lawyer regarding all of these issues. What I would encourage you guys to do is, if you guys have been charged with one of these offenses, definitely give us a call so that we can be more tailor specific to what your needs are and what your circumstances are. I don't have any further questions for you, Herman, today. I'm sure we'll have more videos to come about these issues. Thank you very much.
Thank you.